Now on record for the 8:15 calendar. Review is Rowdy Chester Miller in the courtroom. He is not. Mr. Cooley, I believe is. Mr. Cooley, come on up and have a seat if you would. You're on one of these, what they call SOCs. That's one of the continuances. You were going to get a dismissal if you fulfilled some of the conditions, and one of the conditions was to pay $225 remaining on an agreed amount, but we haven't heard anything. Any reason why you haven't done that?
To be honest, I came in this morning because I don't know exactly what a SOC is. I got your piece of mail in, and I was out confused as ever. So I decided instead of just paying something I don't know, I figured I'd just come in since I had the day off, take an excuse, and enjoy the day.
Pretty easy to lose track of things, but that's why we always give you a copy of the SOC. But people file it away, and I'm looking at it later. And I don't know what happened here, but yeah, apparently the problem is not new violations. You've been staying out of trouble. It's just the money. Chances are the city is willing to probably give you more time to take care of that if you want that. What they could do is move to set aside the continuance. The criminal trespass would be entered as a conviction, and that would. Is that what you'd rather do?
I had no clue what case it was in.
This was a criminal trespass secondary case. Okay. The date of violation was May of last year, May 30th. Okay.
That sounds correct. Yeah, that would probably be one I haven't dealt with in a long time. So
criminal trespass means you were someplace where you weren't supposed to be, and usually it comes up because you're exhibiting behavior which it shouldn't be. I won't go any further, but city moved to set aside, and if that's what you want, the city, I'm sure, may give you more time to take care of the $225 and get the case dismissed, or we can simply convert it to, if the city so moves, to a conviction, and that would, I'm not going to impose any jail time or anything.
Well, the city would like the benefit of its bargain. If Mr. Cooley, if you can, do you have the means to pay the $225?
I mean, I do, but I have a daughter coming in next month, and if there's any revised, plan that can be made for a shorter amount.
How much time do you think it would take you to?
I mean, I can do it, but then again, I'd also like to value my time this morning and all your guys's too, so could have just paid it online last night.
What we would typically do here with the city's permission is give you a court date, say 4 months from now, 3 months from now. And if you're paid up in full, case will be dismissed without you having to appear. But if it's not paid up, you'd have to come back.
Okay, so in a way, it's just a 3-month extension of pay before then.
If you, it's your choice. If you want to end the matter now, excuse me, it would cost you a conviction for criminal trespass, second degree, a misdemeanor. You have a chance to get it off your record,
pay now,
be dismissed if you come up with $225 within a reasonable period of time. What would you like to do? Your choice.
That latter option you talked about, Judge.
You'd like to have some time?
Yes, sir.
We'll set it out. How about October 24th? Now that's
Wait, no. I'm trying to pay it and keep it off of my record.
Yeah.
Your Honor, I think what he's trying to say is, I don't want to put words in his mouth, but he's ready to pay now.
Correct. I don't want anything on my record. Like I said, I don't know what this was in accordance to.
You can pay it now?
Yes.
In that case, pay it now and the case will be dismissed.
Okay. Sorry, I'm more used to traffic infractions and dealing with revised plans that way.
I
appreciate it.
If you'd go to the window outside the courtroom and to your left, remit $225, the case will be on the city's motion.
Appreciate it, Judge.
Closed. Mr. Cooley, I'm going to wish you the best of luck. Always a good idea to not be places where you're not supposed to be or not wanted. We'll simply strike the hearing, dismiss the case, and wish you the best of luck. Everything else going okay in life? Good to hear that. You take care of yourself. Thank you, Mr. Cooley. Alan Downs. You're Alan Dale Downs.
Yes, sir.
Mr. Downs, we have apparently a treatment issue of some kind. You're on a deferred prosecution, which means you're supposed to be in treatment. What's going on in life? The violation is 2016. Case has got quite a little bit of age on it. Mr. Down, what,
City's moving to set aside.
if I set the, you're entitled to a hearing on whether the deferred prosecution is set aside or not. If you agree to that, have the deferred prosecution set aside, what I will do is, based on the reports, I will enter a finding of guilt in your case. I'm not going to sentence you to any jail. I'll give you credit for a day served. All the rest of the jail time will be suspended. There'll be a mandatory fine on that, which is $990.50 in your case. I don't want to pry too much into your medical situation. You know a lot more about what's going on than I do.
It's,
You don't have to answer this question, but what is affected? What
oh,
pancreatic, liver? It could be any one of a number of
it was
things.
a rare aggressive form of prostate cancer.
Got it. Got it. No need to apologize. What I'm mostly focused on here is the fact that apparently, for all intents and purposes, you have been clean and sober for the last 6.5 years. No indication of any new offenses, any new problems with the consumption of alcohol. So
I can't drink alcohol. That's a big.
I know enough to have reached that conclusion based upon what you've told me. Mr. Downs, yeah, we'll simply convert it to a conviction. I don't know if we need a J form. We can do it. Down some paperwork is required here, and we're preparing that as we speak. It looks like you've already made some payments here. You paid 350 towards that. The money isn't important to me. What is important to me is that you stay out of trouble with the law and that you be comfortable and for the rest of whatever time any of us has here. I'll- So we're going to set your payments at 50 a month, beginning August 18th on the remainder of the time. But again, I'm not concerned about that. Nobody's going to be knocking on your door demanding that. So we'll make sure of that. Mr. Downs, I'm signing. Whoop. Got it, I think. Downs signed the order on today's hearing. I want you to get a copy of that at the window outside the courtroom to your left, and you take care of yourself, and best of luck. Mr. Downs, take care. Thank you for appearing.
Did I just go to the window?
Yes, go to the window and tell the clerk who you are, and you'll be given a copy of today's order. Take care. Desiree Edwards is here. Miss Edwards, good to see you. Come on up, have a seat. How are things going with you? It looks like we're making progress, but where are we?
I have to get my results from my drug evaluation on the 22nd.
Well, you don't have that yet? Apparently it's been done, but we don't.
They didn't give it to me. I had to make another.
And you know what they're recommending?
Drug, information school, I think. I mean, that's what she said that she was going to go by, but she had to go and look at, she had to get the records from you guys and.
Ms. Edwards, I realize there's, what I'd like to do is reset the matter to August 29th to give you a chance to, now look, if we get a copy of the evaluation and a compliance report, check and make sure we have that before the court date. And if we have that, you don't need to show up. Is that gonna work? Yeah, what I want you to do is get, follow through. Been a bit of a journey here, and I don't want you to wander off the beaten path yet again. So that's a better late. I've always believed better late than never. The important thing is you're doing okay. You look healthy. You look
444 days.
and counting. That's good to hear. That's good to hear. You keep counting those days, and you know what they say. You know what the saying is: one day at a time. So, yeah, just take care of today. August 29th at 8:15, and again, unless the city has any objection.
No objection from the city.
As long as you're in the compliance, you don't need to waste your time coming in and listening to me bark. You don't need to do that. Ms. Edwards, it's good to see you. You take care of yourself. And again, get a copy of today's order at the window. It'll have the court date on it. And remember, sometimes these treatment agencies are really good about giving you treatment and everything, but they aren't really good about keeping up to date with the court. So check with here and enough time to make sure that we have what we need. And if we don't have it, that'll give you time to get on the agency to, hey,
Thank you.
Ms. Edwards, thank you. You take care. Christopher Jackson does not answer. Dutchy Nuno does not appear to be present. Nick Riggers.
Good morning, Your Honor.
Mr. Narlack, good morning. Mr. Riggers, good morning. How's life?
Good. Very busy, unfortunately.
We'll take up with your matter at this point now. That's Mr. Narlack, anything you want?
Well, Your Honor, given this sort of unique set of circumstances, I think I'll just let Mr. Reigers. We talked about this prior to court. I think you'll just let him fill you in, Your Honor.
I've been on the emergency work order for Mercer Island. My schedule's just been crazy busy. I've been rescheduling with the STOP program to try and get in for treatment. It's not that I don't want to comply. I'm having a difficult time with my work schedule. I've been on site right now for over 28 hours, and I just keep missing my appointments.
Mr. Eggers, you're here. You're addressing the situation. You're doing the best you can. I can't expect anything more than that. What I'm really focusing on here is the lack of any further criminal offenses, and that's the most important thing to me.
Absolutely.
Like what I suggest is not hearing any objection from the city, that we set the matter out for a period of time and give Mr. Eggers a chance to come up to date with his obligations. We have 15.
That sounds reasonable.
The 9th, would you rather go to September?
Mr. Reigers, you probably have a better understanding of what your work schedule is going to be. I just don't want to set you up to fail. What do you think?
If we can go to September, I think I can probably manage to get in. This emergency work order is coming to an end. So I should be able to get it done in the next month or so.
How about September 12th?
That works.
We'll reset the matter for review hearing on September 12th. With this understanding, have Mr. Narlack confirm with us that you're up to date. You don't have to reappear if you're in full compliance with your conditions. But if you're not, if there's still a glitch, if there's still a problem getting started, we'll need to talk to you again in September.
Understood. I'm
going to wish you the best of luck. There'll be an order generated in connection with today's hearing. You and your attorney will get a copy of it, and I'm going to wish you the best of luck. You take care of yourself.
Thank you very much.
Like any questions?
No, Judge. Thank you very much.
Concludes the hearing. You take care.
You too, Judge. Thank you. Have a nice day.
You as well. John Smith. For the record, John Thomas Smith. So again, this is a treatment issue, assessment, ADAS, victim impact panel. Where are we on everything? Wonderful. Could you show that to Mr. Ratfield? That's We keep this for the file, or do you want, we can make a copy? We have, okay, great. We have that, I'll give that back to you then. It's okay. Okay, that's, let's go out to September 12th in this case to give you time to, now, I'm gonna say this again. If you have the evaluation and you're in full compliance according to the agency, you don't have to come back. But if there's still, these things, they go in fits and starts. The problem, what I want you to do is come back in. So, contact us before September 12th. Make sure that we have what we need. And if we do, you don't need to come in. How's life going otherwise?
Pretty good. Not too bad.
That was, you look well, patiently waiting for your case to be called. That was, and yeah, these things, they do take time. But hey, you're following through. That's the important thing. And once again, the whole purpose of it is to make sure that you never have to come in on a similar matter ever again. I'm going to wish you the best of luck, Mr. Smith. You take care of yourself, and well, may not see you on September 12th, but if I do, we'll deal with the matter then. Okay. Now, copy of the order. I want you to get that at the window, September 12th. That's a little ways down the road. I want you to make sure you have that date on your calendar. Good luck to you. Joseph Beneversky. Hold on. Rowdy Chester Miller, Chris Jackson, Betsy Nuno,
Your schedule.
Joseph Beneversky. Come back to those matters for reference.
Set a trial date. Have a pre-trial, either plead guilty, set a trial date. Well, see, we're just out waiting for clock because my understanding. So it's open or not, so they find out. No. I have a feeling that not the feeling that it's like trial date. So he was dead. So then I just before, so I think personally, I think that the city might have. I think they ought to assume now. Before, it's the reality of this, drug charges when you're authority. If they don't. These feelings are really. I don't know one thing, possession of. Not even.
Still don't really want it on my record though. No, I heard.
But that,
I said, I really don't want to know what on my record.
oh, but again, it kind of doesn't.
Professionally wise, professionally wise.
That's true,
it is.
yeah. But I mean, it's like say it's now, it's just, like the first time you convict of it, it's the max is 6 months.
I'm not worried about the time.
Right, right. Well,
That's not what I'm worried about. I'm already gonna be here till October. My time would run out. The max is 180 days.
So.
That was there, but technically.
And I traded out my mattress last night with one of those branding ones, one of those other guys' ones.
No, big gray one. I have,
Yeah, well, I mean, mine was an old gray one, and it was like blown out, where I was like laying through it on the metal.
think it's because the camera's facing down. Good till then. Right. Oh, you're right.
Morning, Mr. Haverko. We're now back on record, regarding the 8:30 in custody calendar. How do you wish to proceed?
Well, first, Your Honor, as to Lance Houston, he's in a quarantine situation right now. There's a infestation, and so he's again, it's a quarantine situation, so that has not been brought out. And I would just ask that that matter be reset to the next court date.
We'll do just that. Reset the matter to August 1.
Okay, and then I have Mr. Lettle here, and I'll have him sit down. Go ahead.
Morning, sir. Is your full name Leighton Easton David Little?
Correct.
Good morning, sir. I'll turn to
Morning.
Attorney Mr. Haverko for how he wishes to proceed. Matter
Thank you, Your Honor. In the interest of additional case discussions, I'm asking to reset this pretrial hearing to August 1st.
Mr. Little, at the request of your attorney, we're going to reset the matter to August 1st. We aren't holding you there. You're there at the behest of a different jurisdiction.
Right.
Are you going to be able to attend court on August 1st?
I'll be here in jail.
He's going to be in custody, Your Honor, till sometime in October.
Oh, boy.
Serving a sentence for Lakewood.
Well, we can readdress the matter on August 1st then.
Yeah, thank you, Judge.
Mr. Little, take care of yourself. We'll be back in session August 1st. In the meanwhile,
You too, enjoy the sun.
you take care.
Okay. He can go back.
Yeah, this is pre-trial.
So the 9 o'clock matter, I'm going to defer to the city for how we wish to proceed here.
Okay, Your Honor.
Just call through the calendar, alphabetically by type. I'll defer to the city.
Yeah, number 2 on the 9 o'clock calendar, or Robert Bailey. Now, it's going to be a continuance. Don't believe it.
Morning, sir. Robert M. Bailey. Good morning. Mr. Crow, good morning. See anything in Oak Courts?
No, Your Honor.
About how far do we want to go out? So, August 1st. August 1, 15, or 29?
I think August 1 would be fine.
Everything's done electronically as soon as sometimes I'm finding this is sometimes a lot slower than the old-fashioned way of pen and paper. But that's where we are. Unless there's a motion, any earlier set conditions of release remain in effect. August 1, 9 o'clock. Signing an order to that effect, electronically, of course. You can get copies of the order at the window before you leave. Mr. Bailey, good luck to you. Take care. We'll see you next month. Mr. Crowe, take care. Bradley Brooks. Morning, Bradley Dale Brooks. Yes, sir. The second. Matter set for a pretrial.
Yes, Your Honor, city's moving to dismiss without prejudice.
Hearing no objection, upon presentation, I'll sign the order dismissing the matter. Mr. Brooks, without prejudice means should the city reconsider further evidence or for whatever reason, they are free to refile the matter within the appropriate time limit. But your attorney will probably tell you that it's rare that happens. So.
Yes, Your Honor.
Sign the order. Get a copy of it at the window, and you take care. Good luck. Take care of yourself. Mr. White, good to see you.
Your Honor. Have a great day.
Good morning.
Good morning, Your
I would so assume. I'll defer to you for the order. Makes it difficult to attend.
Yes, it does. And was he on the speed that
September, yes.
so that we can hopefully
Bull Courts is a little slower than I am today. But go ahead, next case.
next.
And for the previous case, note the non-appearance for speedy trial purposes, but
And there has to be
signing the order as we speak. Ready. Planning an order resetting the matter to August 15th. And I realize out of state drivers like those are the most difficult to resolve. Almost takes a personal appearance sometimes.
And given it's Michigan, it's quite hard.
Oh, Michigan, oh boy. Reset to August 15th. Back to the dashboard, go ahead.
Next. Further.
Hearing no objection, signing an order to that effect as we speak. Resetting the matter to August 15th. Back to the dashboard. They do have the order up on the screen at this point. On the city's motion,
City's motion. Suppose
Motion,
I should,
Brendan?
fix my signature to the motion.
list without. Save signature and close. Got it. That, good to see you. You take care, keep cool, and enjoy the rest of the day. Likewise, and also take care. We do have Zoom presence. Ms. Stevens. Good morning, Mr. Ensing. We'll address your matter at this time. Good morning.
Good morning, Your Honor. I have two on the calendar today. The first is Daniel Barriga, and Mr. Barriga is going to be appearing through counsel under 3.4 today.
Got it. I'm looking at in O courts, there's a motion to continue to August 29th.
And that's correct, Your Honor. We need some more time to negotiate this with the prosecutor's office. He's in treatment with the VA. I've been having difficulties getting that treatment documentation to be able to provide to the city. So hopefully we'll be able to get that and get this sorted out.
Hearing no objection from the city, signing an order resetting the matter as requested. We'll be sending Mr. Barriga and yourself a copy of today's order. August 29th. Those, I think you also have another matter on that.
I do, Your Honor. The last one I have is Justin Mora. This is Mr. Moore is also appearing through counsel under 3.4. It's also a defense motion to continue to August 29th for further negotiation and investigation.
Give you no courts a moment. They've kind of frozen on me here, but.
I was having difficulties this morning as well. It was going really slow for me too.
Nothing unusual about that. As requested, setting Mr. Moore's matter to August 29th. Signing an order to that effect, and the copy will be sent to Mr. Moore and to yourself.
Thank you, Your Honor. And those are my only two matters today.
Hey, you take care. Enjoy the rest of the day.
You as well.
Next month.
See you soon. Thank you, Your Honor.
Rail, it looks like.
And good morning, Your Honor. This is Alistair DeBreo. I'm here for Mr. Matriotti.
Address that matter now. Jared Ryan Matriotti, if I'm pronouncing that correctly. Good morning, sir. Go ahead and have a seat at the council table. Your client is here in the courtroom and having a seat at the council table. Good morning, sir. Full name, Jared Ryan Matriotti. I'll turn to your attorney for the status of the matter.
Yes, Your Honor, and we're asking the court to consider a stipulated order of continuance with the goal of amending the charge to a reckless driving. I did upload that document into O-Court. I just want to make sure with the city that it all looks okay. The only question I had is if there were really any costs associated with it, but I've discussed that with Mr. Matriotti, that there may be a cost to enter this sort of thing in this court.
Redfield, is there, there's usually some kind of an agreement about costs.
Oh, counsel, just a $250 assessment table and $25 monthly installments.
And that's fine, Your Honor.
Looks like $250, $25 a month, said first payment August 1. Is that going to work, Mr. Matriotti?
Yes.
Is there a way to pay it all? That's just the minimum payment. If you wish to take care of it all at one time, that's your choice. What you have here is this is in effect a contract negotiated by your attorney. Between the contract is between yourself and the city, though, obligating to you to do certain things. Those are set forth within the agreement. The most important one is, in my opinion, is that no criminal law violations, especially as it relates to the consumption of alcohol. This is an agreement for a period of 2 years, 24 months. If at the end of 24 months you're in full compliance with with your contract, the charge will be amended to a much less serious conviction for reckless driving. Now, if you violate the agreement, and the city proves that by a preponderance of the evidence, we'll come back here and we'll have a hearing based on the police reports, nothing further. And that would most likely result in a conviction for driving while under the influence of intoxicants. I've said many times, and I'll say it again, a conviction for DUI is much worse in terms of impact on your life than a lot of felony convictions. Your attorney has put you in a position of being able to get this charge reduced to something that's much less serious, but compliance with the agreement now is up to you and not anybody else. Any questions at all? Mr. DeReo, anything to add or any questions about what I've just said?
No, Your Honor, thank you. I'll just let the court know that I did review that document in detail with Mr. Matriotti, and I believe he understands the agreement that he's entering into. Thank you.
Mr. Mariotti, what I want you to do is I'm signing off on the agreement now. I want you to go to the window and get a copy of the agreement. Read it over carefully. And if you have any question at all, what I want you to do is contact your attorney for clarification. I'm going to wish you the best of luck. It's a truism that if we don't learn from our mistakes, we're condemned to repeat them. And every day that I sit here, I invariably talk to somebody that has had to be hit over the head 1, 2, or 3 times and still hasn't learned. So I'm going to wish you the best of luck. Please learn from this for your own safety and health, and so you can move on with life. Okay? Any questions at all? Good luck to you. Take care.
Thank you very much, Your Honor.
Darrell, thank you. You take care. Have a good day.
You as well. Thank you, Mr. Ratfield.
Docket number 6, Jennifer Clark. Okay, yeah, let's take that now. He may be away from the computer.
Okay.
We'll just wait.
There's a read order of continuance on number 1.
I'm having trouble too. That's it. If
So
I won't go back to that.
He requested I join the motion to continue.
Find that. That's all right. Roland Myers. Myers, come on up and have a seat. Mr. Jepson, good morning. Mr. Myers is in the courtroom. He's seated at the council table. We'll address your matter at this time.
All right, good morning. Thank you, Your Honor. This is Connor Jepson on behalf of Mr. Myers. We are asking the court to accept a 2-year SOC in this matter, with the ultimate benefit being a reduction of the charge to a negligent driving in the first degree. I've uploaded that document into O courts. I've reviewed it with Mr. Myers, and I'd ask the court to accept it.
Bradfield City, have anything to add?
Oh, nothing to add, Your Honor. I think the document speaks for itself.
Mr. Myers, I'm no doubt gonna, for the record, your friend is Rowan Bruce Myers is your full name. Now, I'm gonna repeat a few things you probably heard me say just a few moments ago, but I need to repeat them. I'm looking at a SOC stipulated order of continuance. Have you gone over the form with your attorney, discussed it? It's a contract, basically, between yourself and the city, negotiated by your attorney. He's put you in a position of being, of you have the ability to get this charge reduced to a much less serious charge of negligent driving in the first degree, but that won't happen for 24 months. In the meantime, you have to be in full compliance with all of the conditions in the agreement. The most important one of those conditions to me is learn from this mistake. Don't repeat the offense. No criminal law violations, especially involving alcohol. If you violate the agreement, we come back here on a motion to set aside the contract, and the city proves that you violated the agreement by a preponderance of the evidence. We'll have a hearing based on the police reports, and that would most certainly result in a conviction for DUI. And as you heard me say earlier, in my opinion, a DUI conviction is much worse in terms of impact on your daily life than a lot of different felony convictions. So your attorneys put you in this position, but it's up to you to follow through and for the next 24 months, abide by the conditions. Any questions about anything I've just said? Mr. Jepson, any questions about anything I've just said?
No, thank you, Your Honor.
Mr. Myers, I will affix my signature electronically to the agreement. What I want you to do is go to the window, get a copy of it, look it over carefully once again, and if you have any questions at all, give your attorney a call, okay? I'm going to wish you the best of luck and repeat the truism that if we don't learn from our mistakes, we're condemned to repeat them. Please learn from maybe an error in judgment, I don't know, but make sure that the situation is not repeated. Any question at all? Good luck to you. Take care of yourself.
Thank you, Your Honor. Mr. Myers, feel free to call if you need.
Take care. Number 14. Houston Reichel. Good morning, Ms. Ganem. We'll address your matters now.
Good morning, Your Honor. Allison Ganem, present via Zoom, standing in on this matter for Attorney of Record Leanna Cruz. And Your Honor, this is a request to continue. It's a 3.4 appearance. I did have contact with Mr. Reichel. I've explained the waiver that we have executed to accommodate our request to continue this matter.
Ms. Ganem, I'm having a little issue with O courts this morning. They're even slower than I am. So I'm wending my weary way back to the dashboard.
Yeah, I know it was a O court statewide issue yesterday. There was a huge problem.
I didn't have court yesterday, but problem is bleeding over to today. There we go. I now have in front of me an order resetting the matter to August 15th at 9 o'clock in the morning. I'm signing that order as we speak. Mr. Reichel will get a copy of that, as will Ms. Cruz.
Thank you.
Hopefully they are letting me sign this time. And I think you have another matter that's,
I do, Your Honor. I have Mr. Stevens' matter, and I believe I'm hoping he's in the courtroom. We've had contact, we have a resolution planned. I didn't see him in the courtroom, so I've been trying to call and text him, and there is no response at this time.
I'm now informed by Madam Clerk that he's in custody somewhere, so of course he's not here.
Oh, okay. That's terrible. Your Honor, I guess based on that information, I would ask the court to enter an FTA and reset this to the August 15th calendar. That's when Mr. Reichel is also coming back.
Why don't we do this? Let's just note the non-appearance and just simply reset the matter to the 15th.
Okay. Thank you, Your Honor.
You know where he is? He's in the Thurston County Jail for reasons unknown to myself.
Okay.
But I'll sign an order resetting the matter, and we'll just hope that he's available at that time.
All right. Thank you, Your Honor.
Ms. Ganem, thank you. You take care. We'll be sending out copies of the orders. I don't think I'm not sure if we can send one to the jail.
I'll accept on his behalf.
You take care. Have a good day. And nobody else on for. Okay. We'll need a. Why in the world? That might be some is that some kind of a default setting maybe that he has? I don't know. How about, do we need an order on Stevens to reset? Okay. Good morning, Dan, once again. Yeah, weird. Good morning, sir. You're here for the 8:15 and you're Mr. Jackson? Mr. Jackson, come on up. This is in connection with a theft, third, and criminal trespass 2 cases. It looks like the problem is new violations of the law. What's going on there? Because if we strike the hearing, it's simply about. Jackson, what we're gonna do is simply strike the hearing. You still might be under the jurisdiction of Superior Court or this, I don't know. I'm not gonna look that up, but I'm gonna wish you the best of luck. As probably true to say the keys to the jail are right there in your pocket. It's up to you whether you go back in custody or not. And I appreciate that. You take care of yourself and you have a great day. Nope. No, we're just simply going to strike the hearing, subject to renoting should there be any further difficulty, but not being aware of any further difficulty, you don't have to worry about us. Good luck to you. Mr. Jackson, any question? You know, I'm just not worried about any money involved. If there is a fine and it is unpaid, eventually it'll just go to collections. Okay. If there is a fine, always a good idea to, oh no. But what you might want to do is, it's a pretty busy court day, is give us a call here in the next day or two and, yikes. Sigh. It's one thing or another. You take care of yourself. Zero is on. I'm looking for something.
Hello, Your Honor.
Good morning, Mr. Shapiro. Little O Court's issue this morning, but we'll address your matter now. You're appearing on behalf of Jennifer Clark, I believe, with regard to a speeding ticket that was issued, looks like back on April 12th, 2024. You've moved to set aside the FTA. So do you have any objection to me setting aside? I don't have any objection from the city, so I'm going to set aside the FTA.
Thank you, Your Honor.
I think your alternative next request that the matter be set for a contested hearing. Why don't we address that at this time? Do you have any preliminary motions with regard to the any contested hearing?
I do, Your Honor. This is
They might be, but for the record, you may as well recite the foundational one if you would.
Sure thing. Well, Igor Shapiro for the record, Your Honor, on behalf of Ms. Jennifer Clark, cause number 480194406. And upon reviewing the affidavit, Your Honor, I do not see that the officer had certified his speed measuring, his speedometer in his vehicle because he was in moving mode. That is a requirement under the WSP manual. Making a motion to suppress and dismiss.
Motion granted. We'll withdraw the FTA and dismiss the ticket.
Thank you so much, Your Honor. I believe that was my only matter for this morning.
That was it. Now, do you need a copy of an order doing that? We simply do it of record with DOL, but if you want a written order, we can certainly accommodate you.
That'd be great, Your Honor.
It will do. Mr. Shapiro, thanks. You take care of yourself and have a good day.
You as well. And I also want to apologize to your court staff. They've been trying to get me on the hearing.
That's the practice of law. That's I am a 50-year veteran now. I know well how it goes. You take care of yourself. Always good to solve a problem when it jumps up. So you take
I
care.
agree, Your Honor. Thank you. Have a great day.
You as well. Take care.
Bye-bye.
That's it for Zoom. Mr. Redfield, do we have any? Do you want to address no-shows at this time? Mr. Redfield, we could address the no-shows going back to the 8:15.
Chester Miller?
Rowdy Chester Miller did not appear. He's an SOC, city move for warrant.
Yeah, 2,500.
So ordered. And of course, I did not expect Dutchy Nunu to appear. Is that all? Is that in warrant status? It is not. 2,500 cash or bond, warrant will issue. And the last one was Mr. Vinoversky. That's an SOC on a theft third.
City's not going to take any action to disclose that matter.
Then the fine to collections and close. And Mr. Houston was in quarantine, COVID issue of some kind. I guess if it's good enough for the president, it's good enough for Nisqually Jail. And Mr. Little has continued. We do have Karen Boros. She was, Ms. Boros? Does not answer. Ms. Boros is here. Ms. Boros, you're representing yourself in this matter. Have you talked to the city about possible resolution?
What?
No, that's the person you need to talk to.
Why don't we set this?
As far as the purpose of a pretrial is to decide whether or not the case is resolvable by agreement. Given, the criminal offenses, knowing possession of a controlled substance, a conviction bears the possibility of first offense, 6 months in jail. For that reason, it's always a good idea to discuss the possible, or if you change your mind about representing yourself, Mr. Haverco, the public defender, is right there. You want to represent yourself, you're entitled, that's a right you have. But you need to either discuss the matter with Mr. Atfield, or we need to set the matter for trial and it's a criminal matter. The accuser is required to be here at trial, but for a pretrial conference, there isn't any requirement that the accuser, the police. Pardon? Yes, the city. You're making sovereign citizens arguments. I denied. Motion denied. You, what now? No, that's a lot of motions are made about various things relating to the Constitution and the city and parties in interest and living. We're going to reset the matter to August 1st or 15th.
Let's go.
August, we're going to reset the matter to August 15th. Then. Ms. Morris, I guess we'll need an order to that.
Yeah.
That's happened.
Oh, okay.
Ms. Morris, and motions to dismiss based on lack of jurisdiction, et cetera, et cetera, et cetera. The flags on the wrong side of those need to be in writing. It's or I'll listen to them verbally if need be, but I want to advise you, a lot of those standard motions, I'll call them, are just routinely dismissed because they have no basis in law. Ms. Boros, they're generating a notice of hearing here. What I want you to do is go to the clerk's window, get a copy of that, take care of yourself, and by all means, be in touch. Mr. Atfield, do you have contact information with Ms. Boros?
No, I'm not sure I can.
Well, you typically exchange contact information so you can call each other. You want to give them a, do you have a telephone number, Mr.? So be it. You certainly can. You can address as many matters as you want. No problem.
So I received a call this morning from a Christopher Shea. He's, I think on the, I have to look at my calendar, it's either on the 10 or 11 o'clock, but we had a proposed disposition on that. I received a call from him this morning. He says he's having some physical issues about getting out of bed, like his back hurts, he's in some kind of pain. And so he wanted to know if it was possible, if he could appear by way of Zoom. And of course, Your Honor would have to, approve of that. And so I believe he's on hold. The clerk has him on hold. So if with the court's permission, I could advise the clerk that she would be allowed to give him the information to call in, if that's okay with you, Your Honor.
It's okay with me if it's okay with Madam Clerk.
Yeah.
As long as that's fine.
Yeah.
I see there is a forum in Oak Courts, and this is
Right.
Christopher Thomas Shea.
Yeah, so
Okay.
let me talk to the clerk and tell her that he can call in by way of Zoom.
Okay.
Okay.
Justin Rue, yes. Page 7, docket number 16, another pro se, Justin Wayne Ruelos. I think he was the one that definitely declined to be represented by
Right,
Mr.
yeah.
Mr.
Yeah,
Haverhill.
apparently I represented.
I remember. But is Justin Ruelos in the courtroom? He is not.
City staff.
1,000 cash or bond, 2,500. And that I think includes the 9. We do have some 9:45 warrant wash matters. I don't know if anybody's here for that or not. How about Kevin Bordwell? Kevin Bordwell in the courtroom? How about Tim Higgins? Tim Higgins in the court. Mr. Higgins, come on up and have a seat if you would. Doing okay? How about yourself? That was, you're in warrant status. You didn't appear for a sentence compliance hearing.
Yeah, the
Any
last
reason?
date we'd scheduled, I got mixed up on the days.
That happens. Well, Mr. Higgins, why don't, in view of your appearance today, let's reset the matter for a sentence compliance hearing. Let's go to August 1st. Gonna work?
I was just over at CMAR a little bit ago, getting them to print the paperwork out for me.
Perfect. That is what we like. Very definitely what we need. How is life going with you otherwise?
They still got the 8-month-old. So, not a lot of sleep. Pretty good though.
Going pretty, as long as you're here, you're vertical, taking nourishment, and you look healthy and happy.
Just crawling.
Maybe less than happy, but hey, because you got to be here. But what we're going to do is reset the matter to August 15th. I'm signing an order to that effect. Mr. Higgins, warrant quashed. But I want you to go to the window, get a copy of today's order, resetting the matter, and we'll take a look at, see how things are on the 15th. Any questions at all? Take care of yourself. Cooley, I believe is, Mr. Cooley, come on up and have a seat. William Knopf? William Knopf? How about Andrew Woods? Andrew Woods? Gonna get it. It's like Andrew Woods is the only one that does not have a warrant, but was to appear today. The city have a motion with regard to docket number 4, page 9.
Well, we're on Andrew Woods.
Is this Andrew
Yeah,
Woods?
this is Andrew Woods, Jerry.
Mr. Woods, I'm sorry. It's a full name Andrew, middle initial W, Woods. Mr. Woods, you were to appear for an arraignment, but you did not show up, hence
I was in custody.
sorry to hear that. You're out now.
Yeah.
Anyway, the citation alleges that on or about February 22nd of 2024, you committed the offense of knowing possession of a controlled substance. That charge is what they call a gross misdemeanor. On first conviction, the maximum penalty would be 180 days in jail and or a $1,000 fine. I'm going to appoint Mr. Haverco to represent you in this matter, and he'll enter a plea on your behalf at this time.
I'll stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Mr. Woods, a plea of not guilty preserves your rights pending a pretrial. I'm going to sign an order resetting the matter to August 29th. This order will have contact information with Mr. Haverco in it, and he'll need your contact information. Did he move to set aside? If that's what you wanted. May give you more. That's fine.
So before you leave today, just get a copy of the report, take a left turn, go to clerk and show.
Mr. Woods, copy of the order at the window, and we'll see you back here in August. You take care.
There's any replies, plan, be made. Order on that. How much? Collective as my time this morning.
You can pay it now.
Item number
In that case, pay it now.
10 and 11 on the 10 o'clock calendar, Justin Solomoni.
Traffic infraction. Five plants out.
I believe the city has a,
Good morning, sir.
I believe the city has a motion.
Your city's moving to dismiss.
Whoa. Mr. Cooley, for the record, you're Justin Taran Clemente Salamone. If I mispronounce your name, I apologize, but city has moved to dismiss the charges without prejudice. What that means is charges are dismissed at this time, but the city is free to refile them, should they, discover further evidence or review the matter further and decide it's appropriate to refile. Upon presentation, I'll sign an order of dismissal, Mr. Salamone, and that concludes the matter at this time. You take care of yourself. Have a good day. Free to leave.
Did Mr. Shea call in? Okay.
Back on record for the pretrial calendars. Mr. Haverko, I'm going to defer to you for the order in which the cases are
Yeah,
called.
thank you. We're ready to take up 3 matters for Mr. Cahill Williams that are on the 10 o'clock calendar this morning. Item numbers 1, 2, and 3. What the proposal is a 2-year stipulated order of continuance with the dismissal at the end of that period of time of 2 years, provided he remains otherwise law-abiding, no criminal law violations, a $300 fee collectively for all 3 cases to be paid over 2 years. In the document, it says that he either has to show proof continuing participation and then completion of what is referred to as the Family Advocacy Program, domestic violence through the United States Army, which my understanding is that if he terms out of the Army, he'll still be able to participate in that program because he would be under his wife's insurance through the Army, of which she is also in the Army herself. I added language in there that just in the event that for some reason he wasn't able to complete the Army's program, that in the alternative, he needs to get an assessment and participate and complete a state certified domestic violence treatment program. If for some reason the U.S. Army program becomes unavailable. And
I see that.
And I didn't put any language in the SOC, and we can, but essentially the city wants the no contact orders to continue until he has completed the program. Because the current order in place already does allow for child exchanges and some communication for purposes of the children. So it's not anticipated, and we're not asking for removal of the any no contact orders at this time, but will in the future.
Cross that bridge.
Yeah.
When we approach it. Yeah. One for the record, sir, your name Andrew Christopher Cahill Williams.
Yes.
Mr. Cahill Williams, I'm looking at a form in the Oak Court system here. Stipulated order of continuance is what it's called. What it is in reality is a contract between yourself and the city negotiated by your attorney, under the terms of which 24 months from now, this can go away. Charges can be dismissed. If over the next 24 months, you comply with the conditions which have been alluded to by Mr. Haverko. Now, if you violate the conditions in any way, shape, or form, and the city proves that by a preponderance of the evidence, we'll have a hearing based on the police reports, and that could subject you up to 3 days less than 3 years in jail, and some pretty significant fines. You're in a position where you can walk away from this with dismissals. However, you know, whether you do that or not is up to you. These are problematic cases. I keep hearing about cases that have ended in absolute disaster. I hope you're in success. You have somebody there that is you're very, very important in the life of that person. It's up to you to be in a position where you're able to provide for that life. I'll approve the agreement. I'm going to wish you the best of luck. Yeah, and sad to say that you haven't showed a great deal of compliance with the no contact order, but hey, let's not talk about that now. Let's look forward and not back. Yeah. What I want you to do is, you know, go away from the situation, learning what you need to learn, put yourself in a position. Things don't fix by themselves in this arena. We need help to make sure that
And what I would just advise the defendant is in the alternative to setting a review date, I would just suggest to Mr. Cahill is when he's completed the program. Okay.
let us know.
Yeah, just
Subject to renoting.
let me know, and I will cause your cases to be put on the calendar, and I'll get that done. Okay.
We'll do probably the same thing. We'll probably get,
Okay. Sure. Either way. Yeah, it's good.
Mr. Cahill Williams, I have signed the agreement, and I'm available any court date to entertain any motion you have with regard to amending, changing, withdrawing any no contact order or anything else for that matter. I'm going to wish you the best of luck. We learn from our mistakes, so we're condemned to repeat them. I'm hoping that this has been a learning experience, that you're gonna walk away from with, being a much, much better human being in person. It's okay, that's what they do at that age. What I want you to do is go to the window, get a copy of today's order, the agreement, read it over carefully, and give Mr. Haverco a call if you have any conditions at all. Good luck to you. Take care of yourself.
Yeah, you're welcome. Let me know. Next matter would be Joseph Murray.
Full name Joseph Josiah Murray. Mr. Haverco.
Thank you, Your Honor. Sign it. So this is Joseph Murray. Matter comes on before the court for a pretrial hearing. Item number 5, 3 counts, step 3, and then there's a couple of controlled substance violations. It's his intention on entering a plea to count 1, the theft count. Upon the court's acceptance of the plea, city as part of the agreement will move to dismiss counts 2 and 3, and then they are asking typically for the customary probation fee of $250, but we'd like to be heard as to that request.
Again, for the record, Joseph Josiah Allen Murray is your full name. Mr. Murray, I'm looking at a statement of defendant on plea of guilty to 1 count of theft in the 3rd degree. That is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Regardless of what's recommended, I would be free to impose up to the maximum if I saw fit to do so. You realize that. Now, if I accept the plea, likewise, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to the maximum. You realize that as well. That in mind, as to 1 count of theft in the 3rd degree, alleged to have occurred within the city of Yelm on February 2nd, 2024. How do you plead guilty or not guilty? Do you make that plea of your own free will?
You need to answer out loud.
Anybody make any threats or promises to you to make you plead guilty? Find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 of the plea form does satisfy the factual elements of the offense. I've heard sentencing recommendation by the city. Mr. Atfield, anything to add?
Nothing, Your Honor.
Defendant hasn't worked, last worked maybe 2 months ago. He doesn't actually have any current, essentially means of support at the moment. And so asking the court to consider not imposing any financial obligations.
Mr. Murray, you have what they call a right of elocution. Anything you want me to know about the situation, now's the time. You don't have to say anything, but if you have anything you should know, let's speak up. Recommendation is a fair one. I'm going to follow it. 364 days in jail, all suspended on the condition you have law-abiding behavior. Based on your financial situation, you're not working. I'm not inclined to then impose any fine.
And I don't.
Before I close sentencing, there is a compliance with diversion on city wish any action to be taken with regard to that. Mr. Murray, I realize the other 2 charges are being dismissed pursuant to the plea agreement. However, I'm going to leave it up to you to look inward and decide whether or not those dismissed charges have anything to do with the difficulty you find yourself in. Sometimes things run our lives instead of we controlling them. And that's all I can ask you to do is look inward and figure out what you want to do. All I can do is suspend the sentence on the condition you have law-abiding behavior, and that would include not knowingly possess any controlled substance. For some reason, Old Courts is not letting me edit the, maybe if I hit refresh it. I need to hit this and then, there we go. I can wish you the best of luck. Hopefully, life will be better for you. I want you to get a copy of today's paperwork at the window outside the courtroom and to your left. Review it carefully. Give Mr. Everco a call if you have any questions, okay? Any questions of me? Sure. Good luck to you. Signing the document entitled Judgment and Sentence at this time in open court. Okay.
Next matter is Chanthi Niang. It's numbers 6 and 7 on the 10 o'clock calendar. She has a pretrial hearing that comes on before the court for a suspended driving third degree, ignition interlock device violation, and a DUI. I anticipate she's going to enter a straight plea to the DUI charge. Upon the court's acceptance of that plea, the city would move to dismiss counts 1 and 2. The charge is also to be amended to that of a no test, reflecting the under 0.15 sanctions. And I have discussed this matter with her. She has a little bit of a complicated situation. She has an older DUI and she has another pending DUI in City of Milton that I think she has a court date after this. And so she is most likely going to be entering probably a deferred prosecution on the Milton matter. And so this is part of
so this would be a first within.
Correct. Yeah,
Within
this
the
would be
years, if I read that there's no disposition.
That's correct. Yeah, she has no
Got it.
priors within the last 7 years, so this would be the mandatory minimum. No prior offenses within the last 7 years, under 1.5, so it's the mandatory 1 day in jail, $990.50 fine, and the 90-day license suspension. She believes she has done about 24 hours in jail, so that's up to your honor, whether or not to give her credit for that. But ready to proceed.
For the record, your full name is Chanthi, middle initial C, Niang. If I mispronounce your name, I apologize, but I'm looking at a statement of defendant on plea of guilty to 1 count of driving while under the influence of intoxicants. That is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. The plea form also notes a dismissal of the 2 other charges on the citation as well. Now, if I accept your plea, I could give you up to the maximum sentence if I saw fit to do so, regardless of what's recommended. You realize that. And you give up the rights contained in paragraph 5. No trial, no appeal, simply a sentencing. With regard to 1 count of driving while under the influence of intoxicants, alleged to have occurred within the city of Yelm on May 8th, 2024, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Heard some reference to the recommended sentence. Mr. Hatfield, anything to add?
Nothing to add from the city.
Mr. Everco, anything to add with regard to the?
I would just ask the court to perhaps reflect in the judgment and sentence that either she needs to comply with that recommendation, or if there is a subsequent evaluation for deferred prosecution, I would ask your honor to therefore accept that.
Absolutely.
That, I'm assuming you would, so.
Absolutely.
Okay.
Ms. Yang, anything you wish to say?
Okay.
I would, hopefully 3 strikes and you're out. This is now the 3rd time you've been cited with the same offense. And if it is not the last time, I can almost guarantee you that one of these days you're gonna kill yourself, kill somebody else, or wind up sitting in jail for 364 days, and perhaps a lot more than that. You don't want to go there. You don't want to go there. You want to finally, hey, this enough is enough. I'm going to follow the recommendation. I'll find this as a first offense, 364, 363 suspended. I'm going to give you credit for 1 day served because you have done more than enough time. $990.50 is the recommended and mandated penalty in the thing. And yes, if you do enter into a deferred prosecution, the mandated evaluation and follow-up, that'll drop off here and you'll be responsible to the other court up north to fulfill the obligations of a deferred prosecution. No doubt you've learned a little bit about that. Ms. Yang, I can't think of anything else to say to convince you that this is, you're right, you know, kind of on the edge. That's another one of these offenses would be fatal. That's there are courts and not too far away from right here where if you were pleading guilty to this offense there with your record, you might be in jail for about 364 days. But hey, I'm not going to do that. The jail time is suspended, but it's there. If you reoffend, any new criminal law offense, especially if it involves alcohol, might trigger the city to recommend that I put you in jail for 364 days. You don't want to go there. You've either got to learn how to, that alcohol is not your best friend at all. You've got to either learn that or, more to the point, completely separate any drinking you do from any driving you do. That's what you do with your own life is your own business, but when you get out there on the road, that becomes the public's business. So I'm going to wish you the best of luck. I'll sign off on the judgment and sentence. I'll want you to go to the window outside the courtroom, get a copy of today's paperwork, look it over carefully, and give Mr. Everett a call if you have any questions.
And by way of some housekeeping, just to make sure we're clear here, as to the mitigation issue, item number 7, the city was moving the Smiths. So if we could reflect the dismissal.
I meant to address that, and then it went right out of my head. Ms. Niang, I'm going to wish you the best of luck. You take care of yourself. I'm really, really hoping that you come in every time I see you, you're cheerful, you're in a good mood, but boy, I sure hope you don't wind up in any court ever again on that's. I hope you're fully committed to that and there's the necessary follow through. I certainly hope so.
All right. So yeah, before you leave, just go see the clerk and she'll print up your paperwork. Okay. Take care.
Ms. Yang, good luck to you. You take care of yourself.
Mr. Nguyen. Go ahead, sign.
You, Brett, middle initial J. Win. Thank you.
Matter comes on for a pretrial hearing, Your Honor, for a suspended driving first-degree ignition interlock device violation. He's just trying to see if he can make any ground in somehow attempting to get his license reinstated or to get it to a lesser suspended status. So we've submitted into O courts a motion for continuance with a speedy trial waiver. And we'd ask to reset it about 90 days, actually. So it's a long waiver. So we'd ask to set it about 90 days if the parties are willing.
How about October 10th?
Sounds good.
That gonna work? Hearing no objection from the city, we'll reset the matter out to October 10th. we live in a world where you pretty much have to be able to drive to function at all, so
I got two kids. Figure it out.
especially if you have responsibilities. I'm gonna wish you the best of luck with that. Signing an order, resetting the matter, October 10th, 10 o'clock. That's a little time out here. What I want you to do is get a copy of today's order, Mr. Wynn, at the window. Stay in touch with Mr. Haverco, and we'll see you back here, and good luck to you. See you back in the fall.
Jeffrey.
I've already reviewed, here's a copy. of this
Oh,
in the
okay,
file
yeah,
for
then
some
we-
reason, and
yeah,
I've had a chance to review it, and I have.
Okay,
It's,
okay.
Go ahead.
So this is, this is Jeffrey Baker. He has, these are items number 1 and 2 on the 11 o'clock calendar. They all come before the court for a pretrial
For
hearing.
the record, I ought to confirm. For the record, Jeffrey Lee Baker Jr. Okay, go ahead.
Yeah, and they all come before the court for a pretrial hearing on a couple cases with 3 charges in total, alcohol related, and based on everything and the evaluation that I've handed up to the court, we've submitted into O courts a petition for deferred prosecution. It's based on the alcohol evaluation and referral by the Northwest Resources 2, an alcohol treatment referral agency. And we've put both those case numbers on that petition, and asking the court to review it, inquire, and hopefully approve it.
Actually, Mr. Baker, I've been doing this long enough to where I don't really need to, but I have reviewed the petition and the evaluation by Northwest Resources. And I'm glad to see this. I'm glad to see this. City have any input at all?
No, Your Honor.
That's, I've seen cases where people bite the bullet. They say, put me in jail for as long as you want to. I'm going to go right back to living the life I want to live. And you could do that. I've had clients do that. I once had a client sit in jail for 2 years when he could have gotten out if he'd just gone the route you're deciding to go. It looks like your history, I'm not going to go into it on the record, but it's your history is pretty impressive, I might say. That's and it's pretty much up to you. It's pretty much up to you. I'm going to wish you luck with it. There's a lot of speed bumps and detours on the road to clean and sober, but I'm going to wish you the best of luck. And once again, yeah, you've had kind of a rough start here. It's as well as other courts, but hopefully when you fall down, you get back up. I'm approving of the order, and you're entering into a deferred prosecution program. Now, the requirements of that are considerable. I'm not going to go into them. You know full well what they are. The most important one is don't reoffend. And the next important one is go through the programs and learn what you need to learn to keep from reoffending. If we don't learn from our mistakes, we're condemned to repeat them. And this is the kind of mistake that you need help learning why it's committed. I'm gonna wish you the best of luck. You haven't had the best start in life, but I'm hoping that it gets a lot better with time. And I'm pretty sure your view of the world is getting a little more clear than it has been in quite a few years.
So one of the things we're also asking, Your Honor, is, did anyone send me the paperwork? They should have been.
Any bail is exonerated.
Well, what we're asking for is, I think there may still be an order requiring SPRAM. It's anticipated that he's going to go into an inpatient program tomorrow prior to commencing with his deferred program. So
Okay.
I would ask the court to consider removing that requirement because of the expense and on the presumption that
Requirement removed.
Okay.
It's yeah, it's with the disposition unless I continue it in the findings. It's no, it's gone away. Requirement lifted. Mr. Baker, I'm going to wish you the best of luck. Do what you need to do. Just do what you need to do. It's hopefully.
Okay.
You know, you even look better than you did the last time I saw you. That's a little more at ease with yourself in life. That's, Mr. Baker, I can't wish you good luck more sincerely than I am, but you take care of yourself. So.
This is Trevor Tompkins, last name Tompkins, item number 12 on the 11 o'clock. Matter comes before the court today for a pretrial hearing, and there's a statement of defendant on plea of guilty in O courts. And then after the court does its inquiry, he is just done a lot of things that he wants the court to know about to try to rehabilitate himself, and so he's got a number of things that he'd like Your Honor to take a look at after your.
I'd like to hear. For the record, Trevor Lacey Tompkins is your full name. Mr. Tompkins, I'm looking at a statement of defendant on plea of guilty to one count of theft in the 3rd degree. Once again, gross misdemeanor, maximum penalty on conviction be 364 days in jail and or a $5,000 fine, which I'd be free to impose if I saw fit to do so. If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply that sentencing. With that in mind, how do you plead to one count of theft in the 3rd degree alleged to have occurred in the city of Yelm on December 17, 2019? Guilty or not guilty? You do that of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements of the offense.
Okay.
The recommended sentence is pretty fairly standard. But Mr. Tompkins, I'll hear from you. I understand you'd like me to go right ahead. 2019, it's been a little water under the bridge since then, but.
Since I don't want to send many ministries, just for that.
I better late than never. Sometimes we have to go through that valley to get to a higher place. That's just sometimes the way things work out. Sounds like you're in a very, very good place in life, being a good father. That's a business, hey, I'm gonna wish you that luck. It's always good to see somebody turn, be a little proactive. You've had a lot of go on in your life since 2019 in this, and I'm sure you're in a much better place than you were the last time I saw you. My hat's off to you. That's not an easy road that you chose to walk on. That's kind of tough to get down. But I'm going to wish you the best of luck. Of course, I'm going to follow the recommendation. 364, all suspended on the condition you have law-abiding behavior. $250 fine, pay that at $25 a month, first payment August 18th. The money is the least important thing to me. If you have any trouble at all making the payments, let us know and we can deal with that. Up to you. But hey, I want to wish you the best of luck. You take care. It sounds like I don't need to tell you to be good to yourself because you are being good to yourself. And you're being a good father as well. Take care of yourself. And thank you.
You're welcome.
Thank you, ma'am.
Ms. White Plume? This is Alexandra White Plume, item number.
Good afternoon.
13 on the 11 o'clock calendar, comes before the court for a pretrial hearing. The city indicated it might wish to speak with the victim in the case, which may have an effect on resolving the matter. And so we're submitting a motion to continue into courts with a speedy trial waiver. And I guess part of when to reset it would be, how much time do you think the city would need to make contact with the victim, I guess? But, I mean, if you think you can.
August 1. That works for you, Dan?
That's okay.
August 1. Right, well, we're resetting the matter to August 1st. Stay in touch with Mr. Havercoat. We'll see you back here then. I'm signing an order to that effect. August 1, 10 o'clock. I want you to get a copy of today's order at the window outside the courtroom and to your left. Look it over. Stay in touch with Mr. Havercoat. We'll see you back here next month. Any questions? Good luck. Mr. Shea is on standby. He left?
He's not there.
Well, he may reappear in a bit.
I need to speak with Mr. Kilgore. Who's here?
Sure.
Okay.
We'll be in Mr. Shea is back on.
Okay.
But go ahead.
Thank you, Your Honor. So, next matter would be the matter of Christopher Thomas Shea. It's, item number 11 on the 11 o'clock calendar, comes to be, before the court, for a pretrial hearing on a hit and run unattended, charge. I believe we have a resolution of this. I prepared a statement of defendant on a plea of guilty for Mr. Shea, and I believe he's going to enter a plea. He's going to do it by way of an Alford plea. And if I could just make some comments, which is, I have explained to him what an Alford plea is, and he agrees actually with most of the evidence. He agrees that he backed up. He agrees that he left a note without his information. His very, I guess, narrow issue he has an issue with is whether or not there was any damage. And we did discuss that in the police report, the officer does indicate that he observed what he described as a paint transfer. So I guess technically, you know, if you had a paint transfer on your car and you wanted that removed, it would wind up being a repair. But that was the issue that he essentially had with factually, but he otherwise agrees with most of which is in the report.
Good afternoon, sir.
Good afternoon.
Do you disagree with anything at all that Mr. Havercoat just said?
No, Your Honor.
And for the record, your full name is Christopher Thomas Shea.
Correct.
I'm looking at a statement of defendant on plea of guilty to one count of hit and run unattended by way of complicity. That is a simple misdemeanor. The maximum penalty on conviction to be 90 days in jail and or a $1,000 fine. Have you gone over the plea process with Mr. Havercoat?
I have, yes, sir.
Do you have any questions about what it meant to plead guilty to a criminal offense? Were your questions answered?
Yes, they were, Your Honor.
Now, if I accept the plea, I'm free to give up to the maximum by way of sentence, regardless of what's recommended. Also, you give up the rights contained in paragraph 5. No trial, no appeal, simply sentencing. You realize that?
Yes, I do.
With that in mind, as to one count of hit and run unattended, alleged to have occurred within the city of Yelm, within the statute of limitations, how do you plead guilty or not guilty?
Guilty, Your Honor.
You make that plea of your own free will.
I do.
Anybody make any threats or promises to you to make you plead guilty?
No, Your Honor.
I will find the plea to be freely, knowingly, and voluntarily made. And the statement in paragraph 11 simply references that you're making this plea pursuant to the case of State v. Alford. That case, before that case, you had to admit that you were guilty to plead guilty. But that case stands for the proposition that if you want to take advantage of the plea bargain and you've looked over their discovery and realized that things could go bad if the case does go to trial, and you wish to take advantage of that plea bargain by entering a plea of guilty. Is that correct?
Yes, Your Honor.
I have the recommended sentence here. Mr. Bradfield, anything to add? Mr. Havercoat?
Nothing to add, Your Honor.
Mr. Shea, anything you wish to tell me?
No, Your Honor.
That if anything you want to say, now's the time.
No, Your Honor.
There may have been minimal damage, a paint transfer. However, I know a little bit about the industry. A paint transfer can involve a $1,500 bill, believe it or not. It's unbelievable what it costs to repair even this slight minimal damage. And of course, there's always the question of when the damage occurred. In any event, I'm going to follow the recommendation. All jail time, 90 days suspended on the condition. You simply have a law-abiding behavior, and the recommended financial obligation is $250, Mr. Havercoat.
Yes.
You can pay that at the rate of $25 a month. Any questions, Mr. Shea?
No, Your Honor.
We'll be sending you a copy of today's paperwork. I want you to look it over carefully. And then if you have any questions, give Mr. Havercoat a call when you have time to do so, okay?
Yes, sir.
You take care of yourself. Good luck. And always
Thank you, Your Honor.
good idea if there's even a bump in a parking lot, always a good idea to make sure that the other person, there's that contact. You take care.
You as well. Thank you so much.
And thank you. almost. For some reason, after I sign, they won't let me close the thing until I yell at it a little bit. But go ahead. Thank you for your patience.
This is Joseph Nevada, last name Kilgore. I am number 9 on the 11 o'clock calendar. Matter comes before the court for a pretrial hearing on a reckless driving charge, no valid operator's license without identification. He now, and I verified it minutes ago, he is duly licensed now. So I believe the city is going to amend both charges to that of a civil infraction, count 1 from reckless driving to, I believe, negligent driving in the 2nd degree. And then the usual, whatever the amendment is on count number 2 that the city usually amends to.
With.
Yeah.
The with ID.
Right.
So
Okay.
2nd degree.
Yeah.
Well, Mr. Kilgore, for the record, I should say Joseph Nevada Kilgore. For the record, you now have 2 civil infractions. You don't plead guilty or not guilty. You admit them or deny them. You admit that or deny that on May 11th, you committed the infractions of negligent driving in the 2nd degree and no valid operator's license with identification. City have any recommendation as to a fine? Mr. Travico, do you want to? I'm inclined to impose a $250 fine on the neg 1 and a 150 fine on the no license. Do you have a license?
He
Are
does.
you
He
able to
does.
get one?
He is
Okay,
licensed.
great.
Yes, he is.
Mr. Kilgore will do a Kilgore, I'm now signing the order. What I want you to do is get a copy of it at the window out there. Now, driver's license is something you need to get by, function with in life. If you were convicted of the higher offense, there's a suspension that goes along with that. That you know, it's ease up on the driving a little bit, maybe, and the insurance premiums will stay down, and you'll have a valid license. Good luck to you. If there's any problem making the fine payments, let us know. We can certainly deal with that. Any questions? Good luck to you. Take care.
Good luck, sir. Ms. Dietert?
Good afternoon.
I think the city has a motion on the Dietert matter.
I don't hear any objection.
No objection.
I don't have anything in no courts formally. Do I need counting 10, 9, but the T-shirt, that's I want to thank you for your patience, waiting here in court. That's, I want you to just take care of yourself, relax. You'll be free to leave here in a minute. I'll sign it, but you actually are free to leave right now if you want, Ms. Dietert. However, if you want to wait and get a copy of the order, I'll sign that. And you can get a copy at the window outside the courtroom and to your left. I'm still, there we go. I have to hit the refresh button. And then order is now signed. and closed. Yeah, if you want a copy, get it at the window. And any questions at all? Good luck to you. Take it easy and enjoy the rest of the day. We do have a 11 o'clock attorney matter that was scheduled way back when. That's docket numbers 4 and 5, page 13. Archer, Erkenbeck, a reckless driving and it seems to me he was, this person is one of Mr. Baker's friends.
Let me, I think I received an email from Mr.
There is a motion to.
Yeah, Mr. Newcomb and I have been in contact.
How far?
He is.
Uh, 29th of August or September 12th?
Let's go to August. We'll have it.
Okay. August 29th it is. We'll note the non-appearance for speedy trial purposes and reset the matter to August 29th.
It's a waiver of jury trial. So back on record here, this is,
Good afternoon, sir. Leon Kelly the third. Thank you. Mr. Everco?
thank you, Your Honor. Matter comes before the court for a pretrial hearing, and we've submitted into O courts a waiver of jury trial. And so it's a little bit up to the city. We can either set a bench trial now and then a confirmation date. So we're ready to do that at the city.
Yeah.
Okay.
Ooh. Confirmation, August 15th, trial 29th. What?
Yeah, sure.
Sure. Any issues as far as discovery, suppression, et cetera, et cetera?
No.
That's,
None from the defense.
Really what we're doing is we're setting 2 court dates, going to trial. It's kind of crossing the Rubicon. Want to make sure everybody's on the same page. Everybody has what they need to go to trial. That's why we set a confirmation date. Sometimes trial needs to be, because of a number of issues, needs to be changed. 15th, and then trial tentatively scheduled for the 29th of August. If you would, Mr. Kelly, go to the clerk's window and get a copy of today's order. Any questions at all? Take care of yourself. See you back here August 15th. That brings us to the no-shows for the,
On Paul Edward Reed, my
Yeah.
notes reflect, like I called a number that I'd been given on the 12th, left a message to call back, haven't received any return call.
he sometimes is up and sometimes you remember, I'm sure. So ordered. And Mr. Ray Bauman is not here for,
Right? Haven't had any contact.
he was just arrested.
Oh.
He's over at the Nisqually jail, I'm sure.
Okay.
Somebody, officer, I assume Mr. Ray Bauman was booked into Nisqually, maybe? Somewhere, but he's not here. Which is, well, Garrett?
Let's go 1,000.
I don't think it matters whether it's 1,000 or 5, but that's.
No, I don't know.
1,000 pennies or $1,000. Next, Kelly is shuffling. There's a,
Yep.
in Oak Courts, so.
Yeah, I had contact and anticipated we were gonna have a resolution today and wasn't contacted by the defendant as to her non-appearance today, so I don't have any information. I mean, if the city wouldn't object, I guess I'd ask to note the non-appearance for
I'd be
speedy trial
inclined to
purposes and reset.
Note the non-appearance and reset. You've been in touch with her. That's what counts. That goes to 11 o'clock. Well, Kevin Jones.
He does not have a phone, so I don't have any way of
That's
contacting
right,
him.
So ordered. Each charge or each? And that's Ronald Sanchez.
Yeah, I called him as well, had a phone number that I believe is good. Left a message to call me back. I think I called a couple of times, haven't received any kind of return call or contact, so.
Not a surprise.
Don't have any information.
Did find probable cause when he was released. So ordered. And that's the last no-show I have.
Yeah.
That concludes the morning calendars right at 11:56.
All right.
Good afternoon. We'll go on record for the 1 o'clock arraignment matters. There is a matter I'd like to call first. I believe there's a private counsel matter that's Good afternoon, sir.
Hello.
Is your full name Kurt, middle initial J. Boyle?
Yes.
Mr. Boyle, the citation alleges that on or about July 4th, 2024, you committed the offense of driving while under the influence of intoxicants. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. At this point, I'm going to turn to your attorney for the entry of a plea on your behalf at this time. Did he have any? I note there was a 2005 prior. That's beyond the 10 years, but did he have any requests with regard to ignition interlock or?
Nothing out of the ordinary. Standard.
Did he have a position regarding bail?
No objection.
Bail will be exonerated. Mr. Boyle, the conditions of release are fairly straightforward. Don't drive unless you're licensed and insured. Don't drink and drive at all, period. Any officer for any reason asks you to take a breathalyzer, you're to do so. You do appear for court as directed. Have no criminal law violations. Stay in touch with your attorney and appear for court. I can't repeat that often enough. Set the matter for a pretrial. Pretrials, private counsel are done at 9 o'clock. French, we can go up to August 1, 15, 29. What's going to work? 15. Pardon? Oh, that'd be, how about August 29th then? Morning, 9 o'clock. Mr. Boyle, your attorney can appear and may appear by way of Zoom, but I expect you to be here in person.
Okay.
Any objection? Can he come to your office? You're in Tacoma.
We're in Tacoma, so I guess.
It's on the way.
Whether you can appear on.
I mean,
I'd rather have him at your office unless that imposes a hardship.
Either way, right?
I will leave it at that then. Signing an order that takes longer on a computer screen than it does in person. What I want you to do is go to the window outside the courtroom and to your left, and you and your attorney will get copies of today's order. Anything further in this matter? Okay. Mr. Boyle, thank you for appearing. We'll see you back here in August. Take care.
Thank you.
That's it. Any other private counsel matters here? Before I call you up one at the time, I'll need to advise you of a couple of different things. This is your first appearance. It's called an arraignment. You need to know that you're entitled to have a lawyer represent you at all stages of a criminal proceeding, including the arraignment, and throughout the course of the case, should you be indigent, request the services of the public defender. You're presumed to be innocent till guilt is proven beyond a reasonable doubt at a trial. Mr. Havercoat, come on in and have a seat. That's a typically at the arraignment, a plea of not guilty has been entered. That's not any great statement about the case. It's a way of preserving your rights until you can have what they call a pretrial conference. That's a chance for you to discuss your case with your attorney and resolve the case by agreement if possible. Sometimes that's not possible, in which case you have a right to a public and speedy jury trial in the county where the offense is alleged to have been committed. Now, at the end of every hearing, I'll sign an order resetting your case for a pretrial hearing. I want you to give, if you're represented by Mr. Haverko, I want you to give him your contact information and the order that you'll get when you leave the courtroom. Go to the clerk's window, get a copy of today's order, and that'll have his contact information on it. If you have any questions about what you're charged with, or any questions about the matter, don't hesitate to either ask me or Mr. Haverko. It's Cassandra Anderson here. Cassandra Anderson. I'm going to call a number of names, and there won't be any answer. At the end of the calendar, I'll review the case. If there is probable cause to issue the citation in the first place, a warrant will be issued for the arrest of the person who failed to appear. You've saved yourself a warrant by simply showing up today. Cassandra Anderson did not answer. How about Kevin Bingaman? I do not see. Eternity Rose Bach. Ms. Bach, if you come forward, have a seat at the council table next to Mr. Haverko. Full name, Eternity Rose Ellen Bach. Spelled Eileen instead of okay. We'll make a note of that. Citation alleges in honor about July 1st, you committed the offense of criminal trespass, first degree. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Appoint Mr. Haverko to enter a plea on your behalf, and he'll do so at this time.
Stipulate probable cause, ask court to enter not guilty plea.
We have not guilty, reserves your rights pending a pretrial, which we will set for August 29th, 11 o'clock in the morning.
Okay. So you don't have a phone number. Okay, that's okay. So, you need to. I need help.
Of course, is
Oh, gotcha.
kind of locked into a circle here. The line comes up and okay, and then that goes back. So, she goes from the line down to the signature. Everything is done on a computer screen now. It's called the O-Courts system. And I understand that that's been having nothing but issues all day yesterday, and it looks like they've spilled over to today. I want to thank you for your patience, but we'll talk to you as quick as we can get. And of course, it doesn't help that I'm a computer dinosaur and I need assistance to solve whatever problem there is that I don't understand anyway. I want to thank you for your patience. Now, don't forget to get a copy of the order, which has now been signed electronically. Have a good day. See you back here August 29th. How about Ronald Carby? Ronald Carby in the courtroom? Does not answer. Robert Christian? Mr. Christian does not answer. How about Stephen Conway? Let's try Justin David Cook. Michelle Croft. Croft, have a seat if you would. Full name Michelle Leanne Croft. Is that your name? Citation I have alleges that on or about June 29th, 2024, you committed the offense of driving while under the influence of intoxicants. That's a gross misdemeanor. Maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to enter a plea on your behalf. He'll do so at this time, and then we'll set the matter for a pretrial conference. And I want you to give Mr. Haverco your contact information.
Stipulated probable cause, Your Honor, ask the court to enter not guilty plea.
Plea of not guilty does preserve your rights. August 29th, 11 o'clock. Conditions of release are law-abiding behavior. Don't drink and drive any way, shape, or form. Any officer asks you for any reason to take a breathalyzer, and definitely don't drive unless licensed and insured. So, Ms. Croft, any questions at all? Okay.
Sign here with the selected pin.
Huh. Haverco, do you have what you need?
Yes.
Okay. Yeah. Mr. Croft, that concludes the hearing. Excuse me. Concludes the hearing. We'll see you back here in August. Jessica DeGunya. Good afternoon, ma'am. Full name, Jessica, middle initial M, DeGunya. We have a couple of citations here. The first one alleges that on or about July 13th, 2024, you committed the offense of driving a license suspended or revoked third degree, simple misdemeanor, the maximum penalty upon conviction, 90 days and or 1,000. You're also cited for knowing possession of a controlled substance. That's a gross misdemeanor. Maximum penalty on conviction for a first offense would be 180 days and or a $1,000 fine. I'll appoint Mr. Haverco to represent you on these cases as well. He'll enter a plea on your behalf.
Thank you, Your Honor. Would stipulate to probable cause on both matters and would ask the court to enter not guilty, please.
There's also a matter that's ready for pretrial. That's on the next page, page 18, docket number 13.
Right.
Plea of not guilty had been entered on their behalf.
We would,
I presume the request is simply
yeah, I would ask just to reset the older matter. And
Mr. Gunya, condition of release is always law-abiding behavior. Stay out of trouble. Hate to see somebody back here on new citations. We're going to combine all three cases. Expect you back here on the 29th of August. Signing the order, resetting it. What I want you to do is get a copy of today's order and make sure you stay in contact with Mr. Havert. Any questions at all?
Wait 1 second. I have to have it signed. Give me a second. Yeah, so before you leave, go to the window, pick up a copy of your paperwork, and I'll be calling.
Lee Evans or Leah Evans? Good afternoon, ma'am. Is your full name Leah May Evans? Okay. Ms. Evans, the citation I have alleges that on or about July 9th, 2024, you committed the offenses of use of drug paraphernalia and controlled substance, knowing possession of the same. Former charge is a simple misdemeanor, maximum of 90 days and a 1,000 upon conviction. Controlled substance charge is a gross misdemeanor. The maximum for a first offense conviction would be 180 days and or a $1,000 fine. I'll appoint Mr. Haverco to represent you in this matter, Ms. Evans, and he'll enter a pleas on your behalf at this time.
Stipulate to probable cause, Your Honor. Ask the court to enter not guilty, please.
Ms. Evans, a plea of not guilty has been entered on your behalf.
You have a phone number? Go to the window and get a copy of your paperwork, and I'll be contacted.
Conditions of release, law-abiding behavior, and that would include no possession, use of controlled substances. Ms. Evans, we'll see you back here on the 29th. Good luck. Gloria Goldman. Good afternoon, ma'am. Full name, Gloria J. Goldman. Citation I have alleges that on or about July 2nd, 2024, you committed the offense of failure to pay B&O taxes. That's a simple misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. I'm going to appoint Mr. Haverco to represent you in this matter. He's going to enter a plea on your behalf at this time.
Stipulate to probable cause. Ask the court to enter a not guilty, please.
Not guilty. Plead not guilty. Plea of not guilty preserves your rights. Look, a conviction comes in, pleads guilty to any criminal offense. You're looking at maybe up to 90 days in jail. There's so many options available in a criminal offense. That's why pleas of not guilty are also always entered. And now the purpose of that is not to make any great statement about the case, but it's simply to give you time to figure out what's going on, to negotiate. Or
So we're pleading not guilty today? And so you're signing for your next court date?
And this is something you should all just discuss the
Yeah,
matter with
now's
Mr.
not the conversation for that. Yeah, yeah. Yeah. And before you go, you have one more. I'll be contacting you. So before you go, just take a left and get a copy of your paperwork. That'll have your court date and my information. Yep.
Thank you, ma'am. Is Candy Hand in the courtroom? I do not see her. How about John Edward Herzog? Good afternoon, sir. Full name, John Edward Herzog. Citation alleges in honor about, looks like June 30th, 2022, you committed the offense of malicious mischief. Third degree, that's a misdemeanor. The maximum penalty on conviction to be 90 days in jail and or a $1,000 fine. But Mr. Haverco, he already represents you on another matter dating back to April. I'll appoint him to represent you on this case as well.
Would stipulate to probable cause and ask the court to enter not guilty plea. And on the other matter, the pretrial matter, we would ask to reset that and have that track with the new matter.
Mr. Herzog, conditions of release when you were last here were said as law-abiding behavior, and hate to see people back here. Same conditions. I'm not going to have you taken into custody and set bail, but I'm going to ask you to no law violations, okay?
There you go. And you have
David Hunt in the courtroom? David Hunt. Good afternoon, sir. Full name, David William Hunt. Mr. Hunt, the citation I have alleges that on or about July 3rd, 2024, you violated the terms and conditions of a protection order. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you in this matter. He'll enter a plea on your behalf at this time.
stipulate to probable cause, ask the court to enter a not guilty plea.
Mr. Hunt, plea of not guilty reserves your rights, as I indicated earlier. Set the matter for a pretrial. Now, conditions of release are law-abiding behavior, and that would include abiding by any existing no contact order. And of course, stay in touch with Mr. Haverco. Any questions?
Before you leave, just take a left, go to the clerk's window, and she'll give you copies of your paperwork.
Mr. Hunt, thank you for appearing. See you back here next court date. Good luck. Mohammed Camille. Good afternoon, sir. Full name Mohammed Shamil Camille. I probably mispronounced your name, and if I did so, I apologize. If there's a way, I'm always finding new ways to mispronounce names, but I apologize. Citation alleges that on or about July 4th, 2024, you committed the offense of a counterfeiting misdemeanor. The maximum penalty on the conviction would be 90 days in jail and or a $1,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf and represent you in this matter.
Stipulate to probable cause, Your Honor, ask the court to enter a not guilty plea.
Plea of not guilty does preserve your rights. Set it for a pretrial. Again, conditions release, law-abiding behavior. Stay in touch with Mr. Haverco and reappear for court as directed.
So before you leave, take a left turn, go to the clerk's window, and she'll give you copies of your paperwork. Yeah.
Thank you for appearing.
Okay, great.
Christopher Kenny. Good afternoon, sir. Full name Christopher Freedom Kenny. Mr. Kenny, the citation I have alleges that on or about July 12th, 2024, you committed the offense of violating the terms and conditions of a harassment no contact order, 2 counts. Those are gross misdemeanors. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to represent you in this matter. He'll enter a plea on your behalf at this time.
Let's stipulate to probable cause, Your Honor, in both matters. Ask the court to enter not guilty, please.
Mr. Kenny, please, if not guilty or entered on your behalf, that preserves your rights. Conditions to release, law-abiding behavior, and abide by any existing no contact anti-harassment.
Go ahead and have silence. And you have one of them? Before you go to the clerk's window. She'll give you copies of the plea.
Thank you, Mr. Kenny. Take care. Curtis John Kudnikoff does not respond. Caden Long, I do not see. Darren Joseph Matheny. How about Chelsea McCabe? Emmanuel Mendoza. Mr. Mendoza, thank you for appearing. I know your full name is Emmanuel, middle initial L, Mendoza. It's a citation alleges that on or about July 9th, 2024, you committed the offense of driving a license suspended, revoked 2nd degree. Again, gross misdemeanor, maximum penalty on conviction, 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you. I see we already have a pretrial scheduled for August 1 in a different matter. We'll of course take the same date.
Stipulate probable cause, Your Honor. Ask the court to enter not guilty plea on this new case.
Hey, Mr. Mendoza, that's a conditions of release. Again, law-abiding behavior. Don't drive unless you're licensed and insured. You need to talk to Mr. Haverco about that. The only advice I can render right now is, the adage to the effect that when you're in a hole, the first thing to do is stop digging. So, but any questions you have about the matter?
Phone number?
Yeah.
Yeah, so just pick up your paperwork from the clerk before you go. Yeah.
Mr. Mendoza, thank you for appearing. You take care. We'll see you back here in August. That's it. Ethan Nicola. Good afternoon, sir. Full name Ethan, middle initial P, Nicola. Did I pronounce that right? I hope so. Citation alleges in honor about July 7th, 2024. You committed the offense of hit and run attended vehicle. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you in this matter, and he's going to enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Mr. McCullough, plea of not guilty, preserves your rights. We're going to set the matter for a pretrial. Let Mr. Haverco have your contact information.
Okay, all right. Go to see the clerk before you go. She'll give you your paper.
Mr. McCullough, thank you for appearing. We'll see you back here next month. How about Heidi Mulder? Good afternoon, ma'am. Full name Heidi Roberta Molnar. That's it. Citation alleges that on or about July 10th, 2024, you committed the offense of driving while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to enter a plea on your behalf. He'll do so at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Ms. Molnar, a plea of not guilty, preserves your rights. Conditions release in this type of case are law-abiding behavior. Don't drive unless licensed and insured. Don't drink and drive at all in any way, shape, or form. If any officer asks you to take a breathalyzer for any reason whatsoever, you're to do so. Any question at all? Pretrial will be August 29th. We'll see you back here then. Mr. Redfield, there is a prior, but it's 1997, so it's Ms. Mulder, thank you for appearing. You take care. We'll see you back
Before
here
you go.
next month.
I need a phone.
Mulder, thank you for appearing. Take care. Anthony Nelson. Anthony Nelson does not answer. How about Nicole Orvis? Does not answer as well. How about Cody Stikeen Peschel? And I'm quite sure I butchered your name, sir. How do you pronounce your name? Thank you. Citation alleges that on or about July 1, 2024, you committed the offense of theft in the 3rd degree. Once again, that charge is what they call a gross misdemeanor. Maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll ask Mr. Haverco to enter a plea on your behalf, and he'll represent you throughout the course of the matter.
Thank you, Your Honor. Would stipulate probable cause, ask the court to enter a not guilty plea.
August 29th, 10 o'clock will be your pretrial date, and that'll be on the order that you'll get in a moment. Any question at all?
Right here. There you go. Don't leave it up. Give me a phone number. Your phone? Well, so, before you leave, you'll get some paperwork. On that paperwork, there's an email address. Send me an email with your phone number if you get one. I'm gonna make a note right now that you don't have a phone, okay? All right, okay.
Special thank you for appearing. Take care. Romeo Rodriguez. Good afternoon, sir. Is your full name Romeo Elijah Rodriguez?
Yes, sir.
Citation alleges on or about June 25th, 2024, you committed the offense of theft third degree. Once again, that's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to represent you. He'll enter a plea on your behalf.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Mr. Rodriguez, a plea of not guilty has been entered on your behalf. We'll see you back here at a pretrial date. Conditions released, simply law-abiding behavior. Stay out of trouble. Stay in touch with Mr. Haverco. Let him have your contact information, and of course, appear back here for court as directed. And thank you for appearing today.
Just yet. And you have. Yeah, go see the clerk before you go. She'll give you.
Kelsey Shank in the courtroom. Kelsey Shank. No answer. How about Tyler Sorensen? Mr. Sorensen, good to see you. How are you? Not bad. A little warmer than I'd like, but that's the way it is. Full name for the record, Tyler, middle initial J, Sorensen. Sorensen, the citation alleges that on or about July 12th, 2024, he committed the offense of obstructing a law enforcement officer in the performance of his duty. It's a gross misdemeanor. The maximum penalty on conviction would be 364 days jail and or a $5,000 fine. I will appoint Mr. Haverco to represent you on this matter as well. He'll enter a plea on your behalf.
Stipulate probable cause, Your Honor, ask the court to enter a not guilty plea.
Sorensen, a plea of not guilty. Reserves your rights. We're going to set the matter for a pretrial. There's a compliance with a diversion matter as it's been calendared as well. We need to have some, I'm not going to address that today, but the docket indicates that we need some progress made with treatment, evaluation, et cetera, et cetera. We're going to address that at the next hearing. We'll not talk about that today. I'm hoping that progress is made in that general direction. We'll calendar both matters for August 29th at 10 o'clock.
Phone number? Okay, free to go. Just go see the clerk before you go. She'll give you a paper copy of whoever today. Okay.
Sorensen, thank you for appearing. You take care. We'll see you back here at the end of August. Good luck to you. Dylan Stanley. Dylan Stanley in the courtroom. Good afternoon, sir. Full name Dylan Joel Stanley. Say your full name. Citation alleges that on or about December 5th of 2023, you committed the offenses of assault in the 4th degree and 3rd degree theft. Those are both gross misdemeanors. The maximum penalty on conviction would be for each 364 days in jail and or a $5,000 fine. Mr. Stanley, I'm going to appoint Mr. Haverko to represent you in this matter. He's going to enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor. Would ask the court to enter not guilty pleas as to both counts.
Mr. Stanley, any question?
Sure. Sure. Free to go. Just see the clerk before you go and she'll give you the ticket.
Mr. Stanley, thank you for appearing. You take care of yourself. Jebediah Stecker in the courtroom. Jebediah Stecker. Good afternoon, sir. Full name, Jebediah Joseph Stecker. Citation alleges that on or about March 29th, 2024, committed the offenses of the use of drug paraphernalia. That's a simple misdemeanor. The maximum penalty on conviction to be 90 days in jail and or a $1,000 fine. You're also cited for knowing possession of a controlled substance and possession of a alleged drug without a necessary prescription. Both of those are gross misdemeanors. Maximum penalty upon conviction would be 180 days and or a $1,000 fine. I'm going to appoint Mr. Haverko to represent you. He'll enter a plea on your behalf.
I think Your Honor would stipulate to probable cause on all all four cases and ask the court to enter not guilty pleas as to each count.
Mr. Stecker, I should have taken a longer look at the docket. You were also cited.
Right. Four matters.
July 2nd for DDoS second and use of paraphernalia. Both of those are 90 days and or 1,000. Also cited for a second count of controlled substance, knowing possession of that. Maximum again is 180 and or 1,000. Mr. Stecker, law-abiding behavior is a condition of release. Some prosecutors would ask that you be taken into custody and bail set, given the number of cases we're compiling here, but
Okay. So go to the first window and she'll give you a copy of the ticket. Okay.
Stecker, thank you for appearing. Tiara Noel Solis does not respond. Thomas Lehman Dale Thomas does not respond. Ivani Rose Maria Villegas. How about Rashawn Walker? Mr. Walker, good afternoon. Full name, Rashawn, middle initial A, Walker. Mr. Walker, you were cited with the offense of driving license suspended or revoked in the 3rd degree, and the city, in your case, might have a motion.
Yes, Your Honor.
Mr. Walker, do you know what just happened? Show the prosecutor. It should have been reinstated.
Yeah.
Data violation 7/10/24. 7/10/24. Was it reinstated at the time?
It was, Your Honor, the payment was made, received, collected June 6th, but well before.
Walker, I don't know what happened there. Maybe there was a reinstatement fee that was due. Do you have a valid license now on your person? Wait, I'm gonna take your word for it, and the city's moving to dismiss it, dismissed it. If that's a problem with the Department of Licensing, probably maybe a good idea to get a hold of them and find out what they need to do. Oh, boy. Something to take care of, something to take care of. Save you lots of time explaining that to somebody that may not be receptive to your explanation. But Mr. Walker, the charge is dismissed. I'll sign an order of dismissal and that'll take care of the matter. You take care of yourself. If you want an order of dismissal, I will sign that right now. You can get a copy of that and maybe keep it with you. I'm just electronically signing it. The dismissed box is checked. Now electronically signed. Sure, go to the window, get it, tell the office clerk that you want a copy of the order, and good luck to you. Take care. Cheryl Winters. Full name Cheryl Lynn Winters. Same thing applies to you. It looks like you were cited for driving a license suspended or revoked 3rd degree on July 13th, 2024. City may have a motion in your case as well. The motion, which we didn't quite get to in the previous case, was to amend the charge from a criminal offense bearing up to 90 days in jail to a civil infraction. Civil infraction means that if you admit it, you didn't have a valid license on your person, it's a $150 fine. If you deny that you committed the infraction, we can set it for a contested hearing. Now, any question about anything I just said? No, I want to make sure you understand what's driving with your license suspended is a criminal offense, but the city does have a right to amend the charge, and he's amended it down to no valid license on your person. Now, if you admit that you didn't have a valid license on your person, that's not a criminal offense, and it won't have anything to do with suspending your license. I'll assess a $150 fine, and that'll be it. Do you want to go that way? Well, the important thing here is do you know what you need to do to reinstate your license? I'd make that a project. I'd make that a project. I'll assess a $150 fine. You can pay at the rate of $25 a month here. And I want to urge you to get your license reinstated. That's all we can do is try. That's all we can do. Do the best you can. If it makes it impossible to do that and pay the fine as well, I'd rather have you take care of that first. Let us know. Let us know, okay? I want you to get a copy of today's order by going to the window and asking for it. You'll be given the copy of it. Look it over, and if you have any questions, give us a call. Okay, thank you, ma'am. Ms. Winters, good luck to you. Take care. Chia Ebo. Good afternoon, sir. Full name, Ebo Chia. Okay, that's it. You have, it looks like, two civil infractions and one criminal offense. That's page 24, docket number 50. City may have a motion on that one.
Yeah, Your Honor, same motion. And no.
That means you now have three civil infractions. You did have insurance? Oh. So that, well, sure, hey, let me take a look. That effective date, I see it there, effective date, expiration date. You had good insurance. Yeah, it's good. I'll dismiss that. That's the expensive one anyway. That leaves you with two infractions, one speeding. I'm going to dismiss the insurance. You know, I hear that a lot. Cars will be going along and somebody's just following, and for some reason, everybody's speeding, but the one person is the one that gets pulled over and cited. And that's apparently, it was your bad luck day. That was, so you are entitled to have a contested hearing. We can't have that right now, but if you want to contest it, if you admit the two infractions, it'll be 100 on the speeding and 150 on the no valid operator's license. But you're also entitled, we can set this for a contested hearing at a new court date, and that would be August 1. Any question about anything I've just said? What would you like to do? You can either admit the infractions and pay a fine of, it'll be a total of $250, and you can pay that at $25 a month, or you can set it for a contested hearing, and then the city would have to prove that you violated the. I'll dismiss the insurance one, yes, but the only way to get that dismissed is to go to have a hearing on it. Yep. Oh, no. Usually if I assess a fine, 25 a month, usually, 25 a month. Yeah. Is that the way you want to proceed in this?
Yeah,
That's, well, like I said, that's, Mr. Ewell, that's the, we'll set it at 100 on the speeding, 150 on the, you know what you need to do to get your license reinstated? It'd have to be some problem in California. Oh boy, good luck. That's it. Oh, I know. I know that. That's, unfortunately, that seems to be the only way of dealing with it, unfortunately. Sometimes one has no choice. Sibo, thank you very much. Thank you very much. You take it easy. That is it. You can get a copy of the order at the window, and I wish you best of luck. Take care. Thanks. And you as well. And I've called my way through the calendar. Miss Long, that was the same thing last time, but it took you forever to get to court. But for the record, Caden Nicole Long is your name. Citation alleges that on June 17th, 2024, you committed the offense of use of drug paraphernalia. That's a misdemeanor. The maximum penalty and conviction to be 90 days in jail and or a $1,000 fine. You're also cited for loitering in connection with drug related activity. Gross misdemeanor, the maximum penalty would be 180 days and or a $1,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf at this time. You'll do so.
Stipulate to probable cause, Your Honor. Ask the court to enter not guilty, please.
As long a plea of not guilty does preserve your rights.
Phone number or anything? Okay.
We're going to set a pretrial for August 1. Conditions of release are law-abiding behavior, stay out of trouble, and no consumption of controlled substances.
You have a case, another case here on the first? Okay. Gotcha. Well, it's either 10 or 11, one of the two. Okay. Yep.
So 10 o'clock, always a good idea to be on time for court. Sometimes court concludes, ends, and everybody leaves, and that means there's a warrant. You don't want to go there. So you're here today, no problem, but yeah, try and be a little bit better about getting to court on time. the import, we're back on record for the 2:30. It's a little early, but I see somebody is here early. We can take your matter now if you wish. Come on up and let me know who you are and we'll address your case at this time.
All right, I'm Ethan Davis. Thank you.
Mr. Davison, you were cited for speeding on back on May 19th. And you've asked for a contested hearing, I believe.
I actually meant to mitigate it, not contest it. This is my first like real offense being here, doing all the paperwork.
Well, you do have, there's another option. You're entitled to do one deferral on a moving violation and one deferral on a non-moving violation every 7 years. That's a way of keeping it off your record.
Okay.
As a matter, of reality, this is a lot, insurance rates have a lot to do with this. Every court defers things differently. The way I do it is this: hold the ticket for a period of 4 months. If during those 4 months you pay costs in the amount of, what do I usually do? Assess costs of 100, I think it's sometimes 150, but $100, and then attend the traffic safety school online. That's something you can do. There's a number of services. We can give you the info on that. And if you do that, pay the $100, file proof of traffic safety school, ticket is dismissed. It doesn't go on your record as a finding of committed.
Okay.
Are you interested in doing that?
I would like it off my record, so yes.
That's the way of contested hearings. You can win sometimes, but there's no guarantee until a judge rules for you. What we'll do then is we'll give you a deferral. You're entitled to do that with one moving and one non-moving every 7 years. The 100 is due within the 4 months, and of course, don't let the 4 months go by without paying the 100. And that's that. And so, of course, the face amount of the ticket is $268. You don't pay anything on that. I'm signing an order here in a moment, reflecting the ruling here. I want you to get a copy of that by going to the window outside the courtroom to your left. Look it over carefully. If you have any questions, give us a call. Okay?
All right.
No, that's keep in mind that driving a car is probably very likely the most dangerous thing you ever do in your life. Be very careful. All you have to do is turn on the news every morning and you'll see about it's last night's shootings and last night's wrecks, some of which are fatal, both shootings and wrecks. So yeah, slow down, take it easy, relax. Better to get there a little late than never. And I've seen plenty of cases where people never got there. They got somewhere, but it wasn't to where they
didn't make it
wanted to be going. Signing the order electronically. Mr. Davison, get a copy of it at the window. You take care of yourself. And of course, in your own enlightened self-interest, the better your driving record, the lower the insurance premiums. I'm sure you have other things you'd much rather spend your money on than traffic tickets.
Yeah.
Good luck to you.
Thank you.
Take care of yourself.
You too.
I shall. Thank you, ma'am. Think you're here for a 2:30 hearing? You willing to do that now? Come on up and identify yourself for the record, and you. Ms. Roberts, you were issued a no valid operator's license with valid ID, civil infraction. It's not, you do have a right to defer that if you want to, but it's not a moving violation. So it's, like I was saying a minute ago, it's all about insurance premiums.
Yeah.
But if you want, yep. Boy, and this is one of the expensive ones.
Yes, it is.
Madison Roberts, do you have a valid license now? Are you working on it? What's going on?
I'm working on it right now. I've done my written test. I just need to get the driving test out of the way.
$559 is way too much. Let's reduce that to $150 that you can pay at $25 a month. That sounds more sane to me. I'm not sure why that's as high as it is, but yeah, I would make that, you know, we live in a world where you pretty much have to be able to drive to just function at all.
Yeah.
So I'm gonna urge you to, you know, do what you can to get licensed as soon as possible.
Okay.
I'm signing an order, setting that, your payments would be $25 a month. Any issue at all making the payments, let us know, we
No.
can deal with it.
That sounds perfect to me.
Signed and closed. Ms. Roberts, I'm going to wish you the best of luck and the best of luck in getting your license as
Thank
soon as
you.
possible. You take care of yourself.
You too. Have a great day.
I shall, and you as well.
Bye.
Thank you, sir. You take care. Have a good day. Stay cool out there. And now we have, on docket number 3 with Mr. Petros, let me grab that file. Let's take, do I have I'm not sure I have anything for Mr. Wait a minute, there he is. I had the two, I did not separate. Good afternoon, Mr. Grover, you're muted. So go ahead and unmute yourself and we'll address your matter right now, if you wish.
Yes, Your Honor. Can you hear me okay?
No, I absolutely, can you hear me?
Yes, sir. Yes, sir, I can. For the record, Kenneth Grover appearing as counsel on behalf of the defendant, Mr. Petros, who waives his presence today, Your Honor. I do have a few preliminary motions.
I was going to ask if you had any preliminary motions. I'll hear them now.
Thank you, Your Honor. The officer's narrative contains an electronic signature affidavit on page 3 of 3, but that affidavit is not in accordance with RCW 5.50.010 subsection 3E because there is no agency or department that's listed in the signature block, Your Honor.
I think the motion is well taken. I'll grant the motion, and I assume that's followed up by a motion to dismiss. I think your computer may have frozen. Computers, now I can see it. Yeah, for a while you froze there for a moment, the computer issues, but go ahead. Motion granted. I assume there's a motion to dismiss.
Yes, it is, Your Honor. Thank you.
Motion granted. I'll sign an order of dismissal. That'll go out to you in the mail for the satisfaction of your client. Any questions?
No, Your Honor. Thank you very much. I appreciate it, and have a nice afternoon.
Mr. Grover, you as well have a great afternoon. Take care. Stay warm out there. It's going to get, it's not getting any cooler out there.
Okay.
Thank
you.
I get that line across there, and usually after a few seconds, it clicks over to my signature, but it didn't do that this morning, and but it just did that there. Good afternoon, sir. Are you here for a civil infraction? Come on up, have a seat. We'll take your matter now. Tell me who you are.
My name is Jamie Hawk, spelled Jamiehack.
Mr. Hawk, I have you're number 2 on the docket. You're cited for speeding on April 23rd. You've asked for a mitigation hearing.
Yes, Your Honor.
What would you, tell me what you would like me to know about yourself, about what happened here?
Yeah,
I'm willing to reduce it, but give me a reason.
yeah, I'm 32 years old. I have been unemployed for a decent amount of time now. Luckily and positively, I have recently just got a job. I'm employed at the moment.
Great.
So that's really exciting. Happy to be back to work. I got a 16-year-old, soon to be 16-year-old son. He was just been with me for the last few days, hanging out for the summer. He's a baseball fan, so we've been picking up on some baseball practice. And he just recently been accepted to a select team he tried out for.
Oh, hey.
He made a shortstop position, so that's pretty exciting. So that's some of the hobbies we like to partake in.
That's good.
Yeah. As far as the ticket, I am a little familiar with the Yelm area. I just have not been here in years. So I was assuming the speed limit was still 35. I do know I was traveling a little faster than that. I am aware it was 25, and I do check my speed every time I come through now, just because I know how important it is to be traveling at those slow rates of speed. When it's 25, I know it's for a reason. I do pay close attention to my speedometer. I know I'm not the only one who can afford to just, give up money for tickets. So I do know I am at fault, and when people make a mistake, there are consequences. I'm well aware of that. So I'm here to take responsibility for my actions. And I know I have had a court date scheduled for this, so I was trying to take advantage of that today. So I thank you for your time.
Why don't they, thank you for your remarks. They're appreciated. I think, yes, 217 is a little much for that. Why don't we reduce that to 100 even and set your payments at 25 a month?
That'd be awesome.
Is that going to work?
That'd be really nice. Thank you.
Let's do that then. And, I always tell people, hey, we live in a world where everything is just going too fast, including us. Slow down, relax, better late than never. That's, as I again said a few moments ago, driving a car is maybe the most dangerous thing you're ever going to do in your life. So that's slow down, relax, take it easy. It's not a safe thing. First payment due August 18th. If there's any problem making the payments, just let us know. We can deal with that.
Awesome. Thank you so much, Your Honor.
And Mr. Hockey, you can get a copy of today's order by going to the window outside the courtroom and to your left and look it over. And again, any issue making the payments, let us know.
Will do.
Good luck to you.
All right. Have a great day.
And you as well.
Thank you.
That leaves Christopher Sponberg. And the docket tells me he's an inpatient. Let's, any idea when it looks like? No, that's a little rough. Let's see. Today's, why don't we reset that to the 29th of August? Back on record for the 1 o'clock no-shows for the arraignment calendar. The first one I have is Cassandra Anderson, page 16, docket number 1. Find probable cause previously. She was addressed in custody. Probable cause for theft third, 1,000 cash or bond warrant will issue. Kevin Bingaman, find probable cause for loitering and drug-related activity. 1,000 cash or bond warrant will issue for failure to appear. Next one I have is Ronald Carby, docket number 5, page 16. Amend DDoS third to Noval 2 and FTA that to the Department of Licensing. The next one is Robert Christian, docket number 6 and 7. Probable causes previously found for both obstruction, disorderly conduct, resisting arrest, and obstruction, but not enforcement of gambling. So that's 1,000 cash or bond each case. Next would be Stephen Conway, theft third. Find probable cause for the issuance to him of a citation for theft third degree, 1,000 cash or bond. The next one did not appear. Justin Cook. He was dealt with in custody. I found probable cause at that time. Find probable cause for obstructing and paraphernalia, 1,000 cash or bond. Next one I have is Candy Hand. She was dealt with in custody at that time. I found probable cause for the issuance to her of in notice of citation for theft third degree. After that, the next one I have is Curtis Kundikoff. There's a note in the file requesting a reset on that. Note the non-appearance for speedy trial purposes and reset it with notice to Mr. Kundikoff, I think it's pronounced. Next is Darren Matheny, cited for DDoS third. Amend that to Noval 2 and FTA to the Department of Licensing. Kelsey McCabe, find PC for criminal trespass first degree, a 1,000 cash or bond. After that, that's Anthony Nelson. He was dealt with in custody, found probable cause at that time for both theft third and crim tresp 2, 1,000 cash or bond for each charge. Nicole Orvis. She was dealt with in custody many times. Probable cause was found on earlier occasions for theft third, and criminal trespass, 1,000 cash or bond each case. Next would be Kelsey Shank, amend DDoS third to Noval 2 and FTA that. Next is Tiara Zolas, I think, number 43, page 22. Find probable cause for the issuance to her citations for theft third, paraphernalia, knowing possession of controlled substance, and knowing possession of a legend drug without a prescription, 1,000 cash or bond. Next would be Lehman Thomas. Amend DDoS third for him to Noval 2 and FTA to the Department of Licensing. Ivani Villegas, with regard to docket number 45, I do find probable cause for neg 1 and DDoS third, 1,000 cash or bond. She was also cited for malicious mischief third degree. I don't understand that. I can't find probable cause for that. Dismiss the docket number 46. Next would be Cheryl Winters, DDoS third, docket number 48. Amend that to Noval 2 and FTA it. And that is that.